We do have another email question that just came to us. Is there a time limit to use the PIP? My motor vehicle accident occurred in May of 2019 and I never claimed lost wages. Dolores, that is an awesome question. Les, you touched on that earlier in the show.
Right, so the only time limits that I'm aware of by statute are the initial time limits that are imposed, that 14-day time period where you must seek medical treatment in order to preserve your PIP benefits. Now, if you still have PIP benefits remaining, if your wage loss is due to the injuries that you sustained, if you have documentation, you can always submit that to the PIP insurance. Now, the only other issue with it is we talked about statutes of limitations. There is a 5-year statute of limitation for making a claim, a first-party insurance claim. So if you're using your own policy.
Explain that, what a first-party claim is.
Yeah, so first-party is I'm making a claim against my own insurance company. The most common one we see in an automobile accident scenario is uninsured motorist coverage. PIP insurance, of course, but also uninsured motorist coverage, which, we talk about that on the show all the time. You're more likely than not, if you're involved in a wreck, you're going to get hit by somebody that doesn't have insurance or doesn't have enough insurance. And that's because Florida is I think, the only state in the United States that does not require drivers to have bodily injury liability coverage, which is that coverage that if they cause a wreck, their insurance will pay you for your injuries. Florida doesn't have that coverage. They're only required to have the PIP and the property damage liability, which is coverage to fix your vehicle if somebody hits you. So chances are, people that talk about, oh, I got full coverage, chances are they got the minimal coverage and they don't have bodily injury liability. So uninsured motorist coverage is insurance that you buy to step in the shoes of that person that does not have insurance to compensate you for medical bills, pain and suffering, lost wages, future medical, things like that. If you file a first party claim, you have 5 years in the state of Florida to do that because it's based on a contract. Right. So this is where it starts to get a little confusing. We start talking about these legal claims. A negligence injury claim is 2 years now in the state of Florida, but that same negligence injury claim against your own insurance company, if there is no insurance, is 5 years. 5 years. So
general rule of thumb, if you're suing or making a claim against your own insurance company,
go by 2 years.
Oh, yeah.
Yeah, I mean,
that's the shortest. Well,
yeah.
those are considered first-party claims, right?
Right.
Now, going back to Dolores' question, you have to be concerned whether or not she even qualifies for the full $10,000 if she had not been treated by a doctor in the 14 days. So you got to get through that hurdle first and get through that. And then Dolores, assuming that you did, and if you do have any PIP available left on your policy, well, by all means, make your claim for lost wages and submit it to them. Once again, you're dealing with trained professionals on the other side. Hire an attorney, help you out, advocate for you, because trust me, whether it's an adjuster for an insurance company or whether it's an attorney for an insurance company, they are actually advocating on behalf of the insurance company. So you might as well have someone working for you, right, Les?
Yep.